Roger, you want to share your screen?
Okay, give me a second. All right, I'll do that in a minute. Hello, everybody. Welcome to the webinar. I'm Roger Royce, my partner with the law firm of Haynes & Boone. I'm coming to you from sunny Silicon Valley. It's noon on June 9th today, and our topic today is Startup Basics, one in a series, but today we're going to talk about legal, business, and financing strategies in a downturn. As if we're not in a downturn, we've got one coming. Everybody agrees on that. We have people now joining. I can see from our attendee list. This is the first time we've done this with this particular technology, so it might feel a little different to you. But don't worry, you're going to get the same content. You're going to get the same experience, and you'll also get a recording. And if you email me, you'll even get my slides. So before we get going, and while people join, I'm expecting a big crowd because I think this is a big topic right now. I want to take care of a few housekeeping items. First of all, I'd like to thank Idea to IPO, which is probably the largest startup meetup in the world, for putting together these events and making it possible for me to come to you today to discuss these startup basic topics. This is one of a series. You see me about every other week if you follow our webinar series. And we've got an entire summer already programmed. Coming up on July 7, we're doing a panel, a venture capital panel on energy and climate tech. We used to call that clean tech. I guess we call it climate tech now to be a little bit more attractive. On July 14, I will be doing a program I've been doing for 10 years now called Top 10 Legal Mistakes. It just never gets old because people never stop making mistakes. Be sure to tune in for that one. On August 4, we have another panel on one of my favorite topics, agritech, agricultural technology. And on August 11, we're going to do, again, another Startup Basics session, Funding 101 for Startup Entrepreneurs. But for today, we're going to talk about legal, business, and financing strategies in a downturn. I'm going to do slides. People are still joining, but I do want to get going on this. So maybe I'll just ease into people log in. Just shoot an email to our technical team if you have any problems. Yeah, that's the other thing. You'll notice on this screen, it's a little different than platforms you might have noticed, but there is a Q&A dialog box. Somebody's already used it. Thank you. And I will talk about the Asian context. Don't worry. There's also a chat box. Feel free to use that to chat with me. So at the end of the session, I'm going to take your questions. I'm going to take a look at whatever's in the Q&A. And that's what I'm going to respond to. So if you've got a question, put it in Q&A. Don't put it in chat. If I see a chat, that means immediate action. I'm going to stop the presentation, read the chat, answer the question. Use that only for like really important things. I mean 2019 important things, not 2020 important things. Don't chat me if there's a pandemic, if there's a country on fire, if there's a riot. Chat me if you can't hear me, you can't see me, or if Elvis is in my building. Those three things. Everything else, that goes in the Q&A box, okay? All right, let's see if we can share the screen. All righty. All right. Idea to IPO, Startup Basics, Legal, Business, and Financing Strategies in a Downturn. I'm Roger Royce, partner with Haynes & Boone, international law firm based, I am based in Palo Alto, coming to you from sunny Silicon Valley, where today it's, and by the way, we're broadcasting, webcasting all over the world because we're doing, and this will be recorded, so this will be viewed all over the world. I'm in Palo Alto, but you could be anywhere. I see people are logging in from a lot of different countries already. So thank you for joining. Now, one of my personality defects is that I am a lawyer, so you're going to hear a lot of legal discussion here. This is not legal advice. I am a lawyer. I'm not your lawyer. Like I tell I like to tell people, at least not yet. Play your cards right and we could change that. But for today, we're just going to go over a lot of topics, most of which will be legal. Now, not everything, no, will be just legal advice. I do want to talk about quite a few different issues. Some of you might remember that old 70s movie, that Clint Eastwood movie, The Good, the Bad, and the Ugly. Well, that's what I'm going to talk about today. Talk about this downturn. Believe it or not, there are some good things in this. I'm going to talk about some of the bad things, and then towards the end, some of the truly ugly things. And what I'd like you to take away from today is to see maybe where there's some opportunities that you haven't thought of, some things that you can do. Hillary Clinton used to say, never waste a good crisis. Maybe there's something in here that might be good for you. Talk about some of the bad things, how to prepare for that, how to anticipate it, and then how I want to talk about some of the truly terrible things that I want to alert you to. Now, that last one's important, and I want to tell you a little bit about me. Buck Owens used to sing, "If you don't know me, you won't like me." Well, if you don't know me, you won't hear me. So let me tell you, I started my practice out in the Midwest. And I went through out in the oil fields. So I saw oil go up and down. It's down now, in case you were wondering. So I've seen people make millions overnight and lose it just as quickly. So I've seen this before. I also practice in an agricultural area, and I left there in the 80s in one of the worst agricultural recessions certainly in my lifetime. Part of my practice, I kid you not, I represented banks and I have to go down to the courthouse and foreclose. The sheriff would make me put on a bulletproof vest to stand on the courthouse and bid the bank, put the bank's bid in to foreclose on property. You know, I've seen things get really, really bad. I was here during 1988 when Wall Street crashed. I saw that terrible time. I was here during 9/11. I saw what happened to the economy after that, and that was coming off. Remember the dot bombs coming off of that, and then of course 10, 12 years ago, when we had kind of the last probably major recession. So I've seen it go up and I've seen it go down. Now, during all of those events, the reason I'm telling you this is I've seen people make the same mistakes. I don't want you to make those mistakes. I want you to seize the opportunities. I want you to prepare yourself for some of the difficulties, and I want you to avoid making a mistake that might follow you for the rest of your life. So a lot of this is going to be legal. We're going to go fast. I've got 60 slides. I won't get through all of them. I'm going to hit the high points, save your Q&A for the end, put it in the Q&A box. So as I said, the last time we saw this was in 2008. This is not 2008, right? And I talked in my last presentation about the Black Swan Memo, the Sequoia Black Swan Memo of 2008. That was way different. During the last recession, the venture capitalists, they were actually giving money back to their investors. They say, we're not even going to play. We're taking our chips off the table. Things are that bad. Now, the reason I'm mentioning this is because Sequoia put out another memo here a few months ago. The Black Swan Memo was met with alarm in 2008. The one a few months ago was met with a lot of yawns. It basically said, save your cash, protect your customers, be sensible, be logical, don't count on us to help you. Good advice, it's all true, but it's not the alarmism that we saw before. So number one, don't panic. You ought to be thinking about your sources of follow-on capital. One thing we got from that memo, and I think generally is true, is you can't count on your current investors to get you through this. Keep in mind, they're capitalists. They're not charitable organizations, and they're not there to keep you alive if it doesn't make sense to keep you alive. Now, I know you think they might be because you invested with Fund 2 and they're on Fund 3 and 4 now. But don't count on cross-fund investing. That's risky. That's really risky right now. And the traditional wisdom around here is that your round should last a year or two. If you're getting at the end of your runway, if you have less than 6 months runway left, you should be thinking really hard about that follow-on investment because this might last longer than that. And keep in mind that we did a whole presentation last week. It's been recorded. You should go look at it if you want to hear more about venture capital terms and also just how venture capital economics and how they work. But this is where it's really going to put pressure on the VC funded companies. I'm going to get to that towards the end of this presentation. Because remember what I said, the venture model is not current income. The venture model is high growth, right? Because high growth means high valuations. So that means if you're venture funded, you've just been burning through cash all this time. You haven't been making current income. You've been trying to increase value so the valuation can go up, so the VC can show a higher ROI and they can look good to their investors and they can attract the next round until somebody ends up either exiting this company at the end or holding the bag when the company doesn't exit. So keep that in mind. If you're a venture funded company, you probably don't have a lot of income that you can rely on. So you might want to think about changing your thinking about how to approach the market. Now, I would recommend you take a look at the Bain & Company report that just came out, I guess, a month or so ago. Actually, it's longer than that, maybe 2 months, at the beginning of this about how to reorganize and organize in a downturn. Bain & Company, very respected management organization, and they go through some very good recommendations as to what to do with your company. First and foremost, you better protect your customers. You're going to need them. You should protect your employees. I'm going to show you how the government makes that really easy these days. Financial modeling, you want to be able to project. Don't let this sneak up on you. Defend revenue, stabilize operations, reduce costs, of course. And I like this one, play offense. That kind of ties into this pivot language. And but just to pause on that for a minute, if you can take a look, there are opportunities out there. And this is probably the good. And I've seen it. In fact, I've seen companies, some of my clients that we had, I wouldn't say we gave up hope on them, but we had assumed that they were going to have a challenging time going forward, have now come forward and they're doing better now than they would 6 months ago because they're in a business that's in demand. What are those businesses? What should you be thinking about? There's plenty of content on the internet from people at a higher pay rate than me to tell you about that. But in my experience, here's what I've been seeing. Number one, this will surprise you, government contracts, right? The government is still spending money. In fact, it's somewhat of a travesty of justice that all the rest of us have to stay home and can't work. Government employees are still getting paid, right? Government is still doing business. And we have not yet defunded the government. I said this morning we should defund the DMV because it took them so long to get me my pass, but they haven't done that yet. So I was just down there and they're full of people. So if you are in a business that can sell to the government, I would, or if you can be, you might want to think about that as a market. Here's another one that'll surprise you, renewable energy. Personally, I am seeing renewable energy projects and renewable energy technologies that a few years ago were not that interesting, that are now interesting again. Maybe that's your business. And then there's the obvious ones, digital health. Anything that is consumer focused that makes it more convenient for the consumer. We're in the process of doing a whole series of presentations right now on health tech and food for health, because people are very concerned about food safety now and whether their food is going to be safe and secure. Anything that's online, anything that's direct to consumer. The farmers markets seem to have come back, the farm to table type markets. So keep that in mind. Think about changing your business model to something that's going to generate revenue is what I'm trying to say. And those are some ways that you might do that. All right, I'm still on the good. 10 years ago or 12 years ago, people used to walk around and talk about companies that the government deemed too big to fail. Well, guess what? Now could be too small to fail. And that is some of the SBA programs that are available. We have an entire hour and a half on this. Take a look at our content for ID to IPO that we did early at the start of this. If you're interested in this, I advise you to take a look at it. these loan programs are still available. I'm not going to spend a lot of time on them now because we've already done that, but I do want to hit a couple of things. The big one, the one that you've heard about most often, the payroll protection or paycheck protection program loans. So again, we could talk for an hour on this. I've done it already, but just keep in mind that these are loans that protect your payroll. Concept is you take out the loan, you pay your rent, you pay your utilities, you pay your people, and you don't have to lay them off. Instead, you pay them, or if you have laid them off, you rehire them and you pay them. And to the extent that you do that, you do not have to repay the loan. And even if you don't do that, you can still get the loan. You pay it over 5 years, starting in a year, at a 1% interest rate. It's a pretty good deal. Okay, it is, again, it's a government bailout of companies that are too small to fail. And you read in a paper about the large companies that have gotten these. I can tell you that there's tons of small companies have gotten these loans. You should check it out. You still can. And the significant about it, what's different about this and other SBA loans is not only is it super easy to get because the government has guaranteed the banks a pretty darn good return if they make these loans, but also there's no guarantee, there's no security required. All right, just think about that for a minute in this environment. If you're an independent contractor, you do qualify for these loans. You can also get one of these loans. Think about this, even if it's just you by yourself, and part of that will be forgivable. I don't want to get too bogged down in the detail of this because, like I say, we've covered this before. But the amount of the loan is going to be 2.5 times your average monthly payroll. And there are different time periods that you test, either last year or first part of this year. You have to have been in business as of February 15th. There's some exclusions. It excludes 1099 payments, by the way. So everybody asks me that. It's only your W-2 payments plus the payroll expenses on top of the compensation. Now, here's what's recently changed. There's really 3 things. Number one, when you applied for that loan, you have to make a certification that loan is necessary because of economic uncertainty. I had a lot of trouble telling companies that they can make that certification to the SBA under penalties of perjury. And I've seen a lot of companies that had a lot of uncertainty at the time they applied for the loan, but things aren't looking so bad right now. So now what? Are they in trouble? So the SBA recently came out and said that they are going to assume good faith because the world is just so uncertain right now that they're going to assume good faith if your loan is less than $2 million. That's pretty significant. The law has just changed, and I mean has just changed. The bill was signed in the last couple of days to extend the amount of payroll that can be forgiven to 24 weeks instead of 8 weeks, right? So the government's going to pay your payroll for 24 weeks, and it only requires that 60% of the loan be used for payroll costs. The other 40% can be used for mostly rent, but also mortgage interest and utilities. So keep that in mind. And also, if you take a look at the SBA guidance, you should do this now. You really are going to want to have good records. Keep good records. If you're less than $2 million loan, you're not going to be automatically audited by the SBA. If you're more than $2 million, you will be. So you absolutely have to be ready to defend this. If you're less than $2 million, you could be. And I suspect that there's been a lot of fraud in the system. And once things sort out and we all get back to work and things get back to normal, I suspect a growth industry is going to be SBA auditors out auditing companies looking for fraud. And defrauding the federal government is one of the worst things you can do. So, by the way, if you're joining today to find out how to defraud the government out of a loan or how to defraud your creditors or anything like that, just turn your machine off, log off. I don't want you listening. It's not why we're here. We're here to show you how to get the things that you are legitimately entitled to and protect yourself under the law. But unfortunately, I know a lot of people are pushing the envelope on this, and everyone's going to pay for that because you're going to see, my prediction is you're going to see the SBA auditing these loans like avenging angels. So you want to be prepared and you want to have your documentation ready. Yeah, there's the certification I was talking about. The government will assume, actually that 25 is now 40% in my slide, but the government is going to assume good faith in this if it's less $2 million. That's huge. That is really significant, something that really bothered me. Other types of loans, economic injury, disaster loans, again, no guarantees for smaller amounts, no guarantees, no security. They bear interest at 3.75%. They do have to be repaid. There's no forgiveness of these. Up to $2 million, up to $200,000 with no personal guarantee. And again, it's the smaller loans require no collateral and up to a 30-year term. A lot of people got the $10,000 injury advance. That's just free money. You apply for it and they just send you a check like within a couple of days. I don't think that is happening anymore. I haven't heard about that. Okay, government loans. There's a ton of loans. California, where I'm sitting right now, they have tons of loans here, tons of different programs. You should really investigate this. There's lots of resources available. If your issue is short-term liquidity, take a look at the government loans. Not done with the good yet. All right, and my good, bad, ugly. This is where we're still at the part where Clint Eastwood rides into town and saves the sheriff, or however that movie begins. Payroll tax credits. If you don't take a PPP loan, that's important. If you don't take a loan, you could qualify for a refundable payroll tax credit. If I went through this whole slide, I would put you to sleep, even those of you that are in my time zone. So I'm not going to do that. I'm just going to tell you that, refundable payroll tax credits are like gold. Those are like dollars. You actually use them dollar for dollar. It's a tax credit you use against your payroll obligation. So you might not even be profitable or pay income tax, like most of my clients who the VCs don't want them to be profitable. You still get a benefit out of this because you can apply it against payroll costs. Refundable means you file I believe it's IRS form 7200, and you claim the credit and the IRS will just send you the money. So look into this and keep in mind that's a huge benefit. Another benefit is you can defer paying your payroll taxes due to the economic uncertainty resulting from COVID. Now I get this question a lot. Well, gee, that's kind of a tough choice. Which is better? Do I take the Paycheck Protection Program and maybe not have to pay it back? Or do I not take that Paycheck Protection Program, but because I was still a good employer and I kept everybody on payroll, or not, if you've paid people, do I take the credit instead? And unfortunately, the answer is it depends. Okay, it depends. You got to run through the calculation. You just got to do the numbers and find out which is going to end up better for you. So get a good CFO or a good CPA and just crank the numbers. I see a humongous mistake on this slide where it says payment is deductible. That should be non-deductible. So if you get the, I'm sorry, never mind, the tax credit payment. Yeah, so if you take the credit, you don't get the deduction. If you take let me pause on this. This is kind of complicated, but you're not going to get any tax benefit out of a PPP loan, right? And if it gets forgiven, yes, the forgiveness is tax-free. You don't have to pay tax on that forgiveness, but you don't get the deduction for the payment, right? That's just tax law. That's how the federal government is going to help you out on this. California, for state purposes, does it exactly the opposite. So go figure. For state law and other states may be the same way because we have to be different. You have to pay tax on the forgiveness, but then you get a deduction when you pay that same money to your employee. If you take the credit, you don't get the deduction of the payment, however. So it diminishes the value a little bit. Okay, enough tax talk for about a slide. And I want to talk about workouts because we're going into an era of workouts. This used to be, there was a time when I did almost all of this during the last recession. And what do I mean by a workout? It means you're in debt, your company owes money, you got to make a deal with your creditors, and somehow we're going to have to restructure the debt. I call it a workout. And it might not even be debt holders, might be equity holders. But I want to talk about debt, first of all. And you might convert that debt to equity. Say, hey, Mr. Non-bank lender, I know I owe you a lot of money, but can't pay you. What I can do is I can give you stock. Very common. You might say, look, I need the COVID discount. I'll tell you what, I'll give you 50 cents on the dollar. If you take the money now, if you want to wait and take your chances, maybe you get the rest. I'm hearing that a lot myself. Or you might have some, I'm going to get to this at the end, washout financings, mandatory or optional conversions of preferred stock. So let's talk about this. The big issue for you, other than obviously compromising the debt, is your income tax consequence. And I don't want you to be stuck by this. I've seen this over and over, where somebody is, they come to me and they say, oh, you know what? I got great news. My creditor just reduced the amount of the debt. And I'd say, no, that's not good news. That's bad news. And I say, why is that? And I say, because now you got income equal to the amount of the debt reduction. They call that cancellation of debt income. And they'd say, oh, no, that's bad news. And I say, no, that's actually good news. I'd say, why is that? And I'd say, well, because we have all sorts of exclusions to cancellation of debt income. So it's a good thing you came to see me. So this is I'll just warn you, I'm not going to bore you with all the detail. You can read my slides later. It's a complex tax analysis. And the two things I'd like you to walk away from knowing about, well, three things. Number one, cancellation of debt is generally income. If somebody reduces the debt that you owe, you generally are going to have income. Number two, cancellation of debt arises in places that are really surprising. Right? Can't remember the name of the case now. I can't believe it. I don't carry that around in my head. But very famous case where a debtor-creditor got together. They changed the terms of the notes, changed the interest rate, changed the security, changed the maturity. And the IRS came along and said, well, you know what? You just canceled that debt in exchange for another debt instrument. You have a cancellation of debt. Now we got to compare the two and see if we have cancellation of debt income. So be careful of that scenario. Somebody chat me the name of that case. That's going to drive me crazy. It's Cottage Savings. Cottage Savings is the name of the case. Very famous debt modification case. So that's number two. Cancellation of debt will come up in scenarios where you might not expect it. And then number three, there's ways around this. Okay, there's ways out of this problem. I'm spending a lot of time talking about it because it can be huge. I have seen companies get wiped out, not because of the creditors, not because of the debt, but because of taxes, the taxes on the cancellation of debt. So let's be careful about that. Let's be smart about it. Let's plan our way into it and know how bad it's going to be. The biggest exception is if you're insolvent, right? That's how we usually get out of this. By the way, remember in 2016, all of the furor over all the angst over the Trump casinos in Atlantic City, they basically walked away from almost $1 billion worth of debt, paid no tax on that transaction. I want you to think about that for a minute. Here's a business that went and borrowed from its bankers something like $900 million. Took that money, spent it, generated deductions of that amount, probably paid no taxes for years, and at the end, walked away from all that debt and paid no tax. Humongous benefit, perfectly legal. In fact, not only legal, encouraged by our tax code. That was smart planning. As much as you might not like what happened, that was smart planning. People went into that, I think, seeing 6 steps ahead. I want you to be able to see around corners like that yourself. Just plan for the downside so you don't get nailed by taxes if you end up getting a good result with your creditors. If you do rely on the insolvency exception, and I hope you do, if you're going bankrupt to avoid these problems, yes, you're not going to get taxed on that event, but tax is going to be the least of your issues. So I want to leave bankruptcy towards the end. That's where we get into the ugly section of good, bad, ugly. I'm still in the good section, and the good part is that we have this complex rule for reducing what we call tax attributes when that income gets forgiven. Okay, enough said about that because we're halfway through and where am I on slides? All right, I'm doing pretty good. Now, let's talk about the bad. So every one of you should be reviewing your contracts and finding out what your exposure is in case your company doesn't do well and your creditors start to get aggressive. And for example, you might have a lease. You may have guaranteed that lease. You should find out. You might have debt with lenders. You may have guaranteed that debt. A lot of times what we have is what we call bad boy guarantees, which say, look, you only guarantee this debt. This guarantee springs, you have a recourse. You know what recourse means? Recourse means personal liability. It's your problem rather than just liability limited to the asset that you use the money for. You want to look at your guarantees, even though I spelled it wrong in my slide, and find out what kind of recourse you have. And by the way, under a typical bad boy guarantee, you don't have to be bad, you don't have to be a boy. So be careful about that. Read that, just certain things will trip up that guarantee. You want to make sure that doesn't happen. Okay, it could be as simple as a covenant issue. And that's not that is lies on the loan application, but also liens. But I'm going to pause on that for a minute because I'm going to talk more about that when we get to the ugly part of this. Nothing I can do about it now, but just be prepared. We saw this in 2008, people were making up all sorts of stories on their loan applications, and that one, Batman can't save you if you've done that, but you at least ought to understand your exposure. Limited guarantees. Now, there are defenses to guarantees. I'm not going to go through these in details. I've litigated these issues back when I used to litigate. By the way, I'm a business lawyer now. I'm a happy event lawyer. I'm not a litigator, even though I'm going to talk about a lot of litigation. But just keep in mind that there are defenses to guarantees, and most of these defenses revolve around the idea that the lender did something out of your control that puts you at risk. Now, if you have a commercial lender, especially if you're here in California, there's almost a 100% chance that you've waived most of these defenses. But I do want to alert you that there might be ways to mitigate some of your risk under a guarantee. Force majeure. This is a legal doctrine that I learned about 100 years ago in law school, that as soon as I learned it, studied it, checked the box on the bar exam for force majeure, I completely forgot about it, because when are you ever going to need that? I mean, when are we ever going to have, I don't know, a pandemic in this country? That's ridiculous. Or riots in this country, it'll never happen. So I completely forgot about it, like most of us did. But we all put it in our contracts because we're lawyers, we get paid by the word. So you'll find it in a lot of contracts. Well, that force majeure clause has become very important now. People are taking a hard look at that force majeure clause. Look at your contracts. You may be excused from paying some of your obligations if you can't, because of, here's a typical clause. Listen to this one: government regulation, right? Disaster, civil disorder, right? Curtailment of transportation, or any emergency beyond the party's control, making it impossible to perform your obligations under this agreement. Or the one we fight over a lot, acts of God. Well, what's an act of God? Well, if you're here in California, where I am, here in Silicon Valley, where it's nice and sunny and the temperature outside is about the same that it is every other day of the year, we don't worry too much about a lot of otherwise acts of God's, but earthquakes we worry about. Is that an act of God? I'm not sure it is. Up until now, a pandemic, today I think a pandemic is an act of God. I think a riot might be. I think a government regulation probably is not. By this time next fall, pandemics might not be acts of God because they're so expected. Who knows? So that's a fuzzy one, but the rest of these are pretty darn specific. Look at your contracts. Now, what if you don't have a force majeure clause in your contract? Are you a dead duck? No. In fact, you might be better off, because a lot of the force majeure clauses that I read say just kind of the opposite. They say, by the way, guys, this is not a force majeure clause. You don't believe me, go look at your insurance policy, where they have smart lawyers writing these contracts. You'll be surprised at how little is a force majeure. So let's suppose you don't have a force majeure clause, but still you're in a business where you can't perform because of what's going on, because of sheltering, because of COVID, because of riots, whatever it is. Well, there are two doctrines I'd like you to know about. And again, I'm just alerting you to the issues, not answering any questions right now, because these are very fact-specific ideas. One is impracticality, and that is the idea that it becomes just unreasonably difficult to perform under a contract because of changes in circumstances. It just becomes impossible or unreasonable. That's a common law doctrine. Now, common law means that it's been passed down through case law, maybe all the way back to England, right? So that's the doctrine of impracticality. So, for example, if you and I contract that I'm going to buy a bunch of face masks from China, and it turns out that the government, now completely shuts the border and closes down trade with China. You might have a defense that, look, you can't sue me for not delivering those masks. The government won't let me. This contract has become impossible. It's codified for sale of goods under our Uniform Commercial Code. Read that at your leisure. One, I want you to just think about, has your contract become impractical or impossible? Can you get out? Second doctrine, frustration of purpose. Little different than impossibility. Under this doctrine, you can perform, but it would be kind of pointless. So the case, again, this is a common law doctrine. The case that we all learned 100 years ago was the fellow who rented the room in downtown London on the streets so he could watch the king march by during the coronation. And the king wasn't feeling good that day, and he decided not to have his parade. And he said, look, though my purpose has been frustrated, I shouldn't have to pay you for the room. I don't need it anymore. Again, there are the legal standards on my slide. Keep in mind. And by the way, the key with this one is that it's such a severe and substantial change that it could not fairly be regarded as one of the risks that was anticipated or that could have been assumed under the contract. And again, you can contract out of this as well. If you've got a good contract, it might just say, rain or shine, whether the king shows up or not, you're going to pay for the room. All right, business interruption insurance. Take a look at your insurance policies. You might be covered, okay? You might be. You got to read that policy carefully. You might be covered for a lot of things. You might be covered for a lot of costs, a lot of damages that you have, including lost revenue, believe it or not, because of things that are covered by your business interruption insurance. Now, there will likely be carve-outs for certain types of acts, and that might include a pandemic. I just looked at an insurance contract the other day that had that language. Secondly, typically you're going to get the interruption insurance for as long as you need it to restore. And thirdly, you have an obligation to mitigate. You know what mitigate means? It means to make less. You got to mitigate damages. You have to make them less, right? If you can continue your business by working from home, you have to do that. You can't just go on vacation and come and collect under your insurance policy. Take a look at your policy. A lot of people don't even think. Believe it or not, you should be looking at your homeowner's policies. You'd be surprised what you'll find in there. Speaking of insurance, I'm going to mention this again a few times in the next half hour. D&O insurance, you might want to dust off that policy and make sure it's still in force. For God's sake, don't let it lapse, because if things go really bad, people might be coming after you personally as a director or an officer. You need to be insured. That is the second most important thing to pay for right now, your D&O premiums. I'm going to tell you what the first most important thing is in a little bit. It protects your personal assets. It covers suits by shareholders, creditors, predators, other people who want to come after you. It does not protect you from your own misconduct. So if you've done something willful, like I say, don't be looking for your D&O insurance. Okay, moving along. I really want to talk about fraudulent conveyances. So what was the most popular documentary of the season? We were all sitting at home. We had no place else to go. Couldn't go to the bar, couldn't go to the restaurant, couldn't go to nightclubs. We were sitting home watching documentaries. Did you see Tiger King? Remember towards the end of Tiger King, do you remember when that poor little old lady, that old woman, the Tiger King's mother, ended up being sued, and creditor was in a position to take everything away. I don't even have to look at that pleading. I know what happened. I've seen it 100 times. What happened is the son got in trouble. I hope he doesn't sue me for saying this if I'm wrong, but I believe what happened is the son got in trouble, had some judgments against him. Sheriff was about to come and, send someone like me with a bulletproof vest to take the land away and sell it at auction. So he said, well, I know what I'm going to do about that. I'm just going to transfer that property to my mother. So the creditor has to start all over and sue the mother. And of course, he didn't think it through that far because that's what creditors will do. So I see this all the time, and people ask me, they say, hey, can I avoid any of this exposure by transferring this property to my mother, my father, my brother, my cat, my dog, whoever? I say, sure, if you don't mind making them defendants. You don't want to do that, right? You want to be very careful about any sort of transfer in a couple of situations. And here's the situations. So listen super carefully, because this is one of those things that you can do to actually make it worse. All right. Number one, if you are already insolvent, or if the transfer of property would make you insolvent, don't do it, right? That's going to be a fraudulent transaction. We all call it voidable transactions because we're in an age where we don't like to use, harsh language if we can use nice language. So I guess we can't call this the rainbows and unicorns transaction, but we'll call it an avoidable transaction. It's still the same thing. They're going to go sue whoever you transferred it to. All right. Don't do it. If that transaction makes you insolvent, so your creditors, your present creditors, or people that you can anticipate and are anticipating are going to be creditors, might come after it. Doesn't cover unknown creditors, right? So that's where we get into this whole area of what they call asset protection planning. Now, if you're insolvent, it's too late. If somebody's made a claim against you, it's probably too late, right? I know lawyers out there who will say, well, we'll help you in that scenario anyway. I'm not one of them, all right? Lawyers get sued when they do that sort of planning, so don't come to me. I'll just warn you, this is a very powerful tool, this Avoidable Transaction Act. And you should be aware of it before you take any action you can make. Okay, I'd still give you two scenarios. One is if you're insolvent, or if by giving your property away. And by the way, you know what I mean by insolvent? It means your liabilities exceed your assets. You can't pay your debts. That's something that's subject to interpretation as well sometimes. Number two, what's the other time that you don't want to make a transfer? The other time is if you're doing it to actually keep somebody from collecting on their debt. That's another area where you can get into trouble. Not only doesn't it work, but you expose the person that you transferred the property to potential liability. Not a good idea. And I want to remind you that it actually is a crime in California to do this. And if you don't believe me, I can tell you of people who have been criminally prosecuted for doing this. This is serious stuff. And but it pales in comparison to what a bankruptcy court will do to you if you try to do a fraudulent conveyance and intentionally, and then use bankruptcy to get out of your debts. Bankruptcy fraud is one of the worst things that anybody can do, because bankruptcy judges, I've seen them, let me put it that way, I've seen them in action. They don't like this stuff. They don't like you using their court to do something fraudulent. Other personal liability. Take a look. Do you have contractual liability? You might think that lease it belongs only to your company and you can walk away, but you may have guaranteed it. It's a personal guarantee. You might be a co-obligor on some of your contracts. I'll tell you what, you might have screwed up on signing a contract and accidentally signed in your individual capacity instead of your corporate capacity. I see people do that a lot, and then we fight about it. At the end when things go bad, you might want to know that. You might want to review your documents and make sure everything's nice and tight, or if it's not, at least you know where the skeletons are. And you might have pledged security interests, you might have pledged stock, you might have pledged interest in assets. There was a time during the last frothy run-up that people were happy to put up their retirement plan to fund their business, give mortgages against their house, stuff like that. I've seen that. I've seen that recently. There's not much I can do for you. If you've already done that, there may be defenses, but you should at least take a look and understand where you are. Okay, now I'm going to get to the truly ugly stuff. Remember how I told you those D&O premiums are probably the second thing you want to pay? What's the first thing? First thing you want to pay is what they call trust fund taxes. All right, payroll taxes. And by the way, I'm primarily a tax lawyer. I've been dealing with this issue for 35 years. I know what the IRS can be like. I know what the EDD can be like on this. I got a call just this week, so listen to this, from the Midwest. I got a call from a lawyer saying, is this for real? Can this really be happening? To my client who is a bookkeeper for a company and decided to do a favor for a startup founder and came in and did his books for him, right? Next thing you know, the IRS is after her for all the payroll taxes that the company didn't pay. How does that happen? She's just a bookkeeper. She did a favor. She didn't get paid for it, but they were chasing her. And it didn't matter, that we had a good explanation. It didn't matter that he tells me that he went into the audit and he said, look, she's just a bookkeeper. She didn't sign any checks. They're now in appeals. It's going to cost her a fortune to get out of this. She may have to go to tax court, but the IRS takes a very aggressive view as to who is a responsible person and who was the person who was responsible for those payroll taxes not being paid. What do I mean by payroll taxes? Every employer has to withhold on every employee, right? If they're owed $1,000 and $200 of that tax, the employer pays them $800 and they take the other $200 and they put it in a deposit account so it gets paid to the government. Well, let's suppose you're saying, I could really use that $200 right now. I'll pay the government later. I got to pay my rent today, or I won't even be around tomorrow to employ this employee. I'm doing the employee a favor. They ought to thank me for not depositing her taxes with the government, saving her job. Government doesn't look at it that way. As far as they're concerned, you took their $200 and you better give it back. And not just you, the company, but anybody who is responsible for that. Same in California, same with the EDD. EDD, that's our Employment Development Department. They can assess 100% of the tax due to anyone who is deemed a responsible person. It's not as bad here because there are all sorts of offsets. The taxes are smaller. Hopefully the employee paid their income tax. There are defenses. So I'll tell you, there's defenses to all of these claims, right? We can get you out of this stuff a lot of times, but you're way better off not getting in that position in the first place. So pay your taxes, pay your employment taxes. And I'm not personally aware of the Justice Department going after anybody criminally, but I am anecdotally. I know other lawyers who have had those cases. Other state taxes, believe it or not, in California, you are individually responsible for sales tax. I've never seen the state go after someone for that. Unemployment, workers' comp, disability tax. I want to pause on workers' comp for a minute. That is super expensive here in California. It is super expensive here. And it's a California thing. It's 10 times here in California than what it is in other states. Don't want to mention any by name, Texas, but I've had people tell me since they moved, their workers' comp went down by 90%. It's because it's so expensive, people sometimes don't pay it. They try to get out of it. And because of that, enforcement has to ratchet up. This is one of those areas where an officer or a stockholder can actually have criminal liability for not paying a charge. So don't screw around with workers' comp, even though it costs a lot. How are we doing on time? 10 minutes left. Oh, geez, not doing great at all. I'm going to move fast now. Bad checks, every 4-year-old knows that you don't write bad checks. Here's one you probably didn't know. You might have liability on your company credit card. Look at the agreement. Take a look at the card member agreement. Different card member agreements say different things. Improper distributions. If your corporation is insolvent, you can't take a dividend. Don't do it. You'll have to give it back. Same with loans and guarantees. Here's one you might not have believed or known about. Did you know that you, an officer of the company, you might have personal liability for wages that don't get paid? Now, the Labor Department can go after you, or a private litigant, an employee can go after you. I'm not aware of the Labor Department using this particular section to go after an employer unless there's some willfulness component to it. But that doesn't mean that they can't. They could be aggressive. So pay your wages. That's one of those priority claims that should get paid. ERISA. Don't mess around with your company's 401k. And by the way, of all the agencies I've mentioned so far, the Department of Labor is probably the toughest, right? They're on a mission to protect the retirement plans of their people. So you don't want to tangle with them. They can be very tough. Circular environmental liability, individuals can have liability for dirtying up the environment. Okay, I want to pause on this one for a minute because this is another sleeper, one you might not have thought about. I wish we had more time. Fraudulent failure to pay. So your company enters into a contract, things go wrong, you can't pay the contract, but you're thinking, well, you know what, I formed a corporation, they're not going to come after me, they're going to come after the company, I think I'm in the clear. Not always. You're seeing more and more creditors are going to make a claim of fraud. They're going to say, look, at the time we entered into that contract, you did not intend to pay me. I know you didn't because you couldn't possibly have, right? You didn't have the money and you didn't have any good prospects. I'm seeing that more and more. Be careful about that. Again, it may be too late now, but going forward, as you do business and you deal with your vendors, make sure you're upfront. You don't say anything untrue. Bank fraud, wire fraud, securities and exchange. You ever needed to be honest, now is the time to do it, especially if you're selling securities. We could talk a lot about unregistered brokers, unaccredited investors, but I want to get to some more good stuff. Alter ego claims. Almost every litigator, those are people who actually try lawsuits I've met, thinks that they can pierce the corporate veil and get behind a corporation. And just because you came to me and I set up a corporation for you, if that corporation fails, they can sue you, the shareholder, personally. I hear that from almost all of them. They raise that claim all the time. I will tell you that I've been practicing for 35 years. I've formed thousands of companies. Never once has one of them been pierced. You know why? Because we did it right. Make sure you do it right. Make sure you follow all of these formalities. And the number one thing here to keep, to make sure you have that limited liability is the money, because the liability will follow the money. Judges don't want to set stuff aside because you forgot to have an annual meeting and sign your minutes, but they don't mind bringing you responsible if you took the money out. Reverse veil piercing means that the corporation is liable for your debts. That happens. Man, I've got a half hour on fiduciary claims. What I want to leave you with is a couple of things. Number one, you're protected by the business judgment rule. Just because your business failed doesn't mean that you're going to get sued, right? Courts, especially Delaware courts, where for most of my companies, are not going to substitute their business judgment for yours. You made a bad decision, okay. There's exceptions to that. If you violated one of these duties, loyalty, care, good faith, in other words, you were on both sides of the transaction. You had an interested board of directors. If you somehow personally benefited from it, maybe you weren't careful, then a court is going to look at it and they're going to judge a transaction by the entire fairness standard, and the burden of proof shifts. That might not mean much to you, but to a lawyer, it means a lot. It means you got to prove that the transaction was fair under an entire fairness standard. The other thing is duties to creditors, right? You owe fiduciary duties to stockholders, that's equity holders. As a general rule, you don't owe fiduciary duties to creditors. What do I mean by that? I mean by a duty of loyalty, a duty of care. Your creditor is not going to sue you because you made bad business decisions. Generally, your creditor is not going to sue you because you were an interested party or whatever. Generally, however, once that company becomes insolvent and there's nothing left for the equity anymore, well, then you might owe the same duties you owe stockholders, duties of loyalty, duties of care, duties of good faith to the creditors. And now you've got a whole new class of plaintiffs. Be careful about that. You might owe your creditors more than you think you do. All right, my last few minutes here. I want to just skim the surface of troubled terms for venture capitalists. Your company is not going to do as well in the next round. You're probably going to do a down round. You know what a down round is? Down round means that your valuation is lower than it was in the last round. Okay, that's not going to be great, but it's better than nothing. It means you're getting new cash, just everybody's unhappy. A couple things to think about. You don't want to get sued because you've done a down round. So a few things. Shop the financing. If you can avoid it, don't do an insider round, go shop it. put it out to the VC community and make sure that what you're doing is market. We call that market testing. Do a rights offering. That means make the offer that your insider VC that down round are doing, let everybody in the company participate in that. Make sure your D&O insurance is paid in case it goes wrong. Communicate with your employees as to what's happening. You may have to reprice their options. You know what I mean by repricing an option? My option is underwater now. I've got a right to buy stock for $1 a share under my option. The stock's only worth 50 cents a share based on that down round. Repricing means you go back and you reset the price at 50 cents. There's tax issues, there's securities laws issues, there's probably a Rule 701 issue, it might be a tender offer. There's lots to worry about when you do that. Don't do that without a lawyer, but keep in mind there are ways of protecting people in that scenario. Here's some cases, people got it wrong, people got sued. This one I pulled off the internet, so I'm not speaking out of turn. Troubled company valuations, low valuations, penny warrants you'll see sometimes. In other words, I'm going to make an investment. You give me a warrant to buy another 10% of this company for a small amount of money. I'm going through this super fast, so I just want to mention pay to play. What is pay to play? Pay to play is the idea that the investors, when they came in, they got all these rights. All right, they got preferences. They got voting rights, they got conversion rights, they got all these rights. Pay to play says, look, you only keep those rights if you put more money in the company. That's a pay to play provision. If you don't pay, then your preferred stock will convert now to common stock or a shadow preferred that doesn't have all these rights that were heavily negotiated. Pay to play can be really super ugly. I can tell you stories about getting wiped out in pay to play, but I'll tell you what, it's not as bad as, where's my slide? It's not as bad as what the preferences can do in a down round and an insider deal. And I tell the story a lot when I speak at ID to IPO events about the company that came to me. The founders were forced out of the company. 10 years later, they read about the sale of the company in the newspapers for $500 million. The founders got zero out of it. Zero out of it, $500 million exit. They were founders, not one of them. Not even a Series A got anything out of it, not even a Series B. That's down round, insider round, preferences, multiple preferences. The company would have had to sell for $1 billion before the founders would have seen anything. That stuff happens, and you're going to see those sorts of provisions being put in place. Again, unsuccessful exit. These are not happy events. We sell the company. Maybe it's an acquire. People buy the company just to get people. There's issues all over the place about this. Before you do something like this, you'll need legal advice. Here's another case where everybody got sued, the company sold. And here's how it happens. We have preferred stock preferences. Remember from our earlier session what a preference is. That means the preferred stock gets their money back, sometimes a multiple of their money back before the common stock gets anything. Sale of the company doesn't clear the preferences. You got $10 million of preferences and you sell the company for $8 million. That means only the preferred stock gets paid. Well, the founders say, well, I'm not going to participate in that deal. There's nothing in it for me. Why should I? So we do a carve out. We do a management incentive plan. Say, look, we're going to give you, in this case, I guess, maybe it's a $100 million sale. We'll give you $7.8 million off the top just for you, management. That's a pretty good payday. Just get the deal done, right? Tell the buyer you're going to go along with them. You're going to bring your people. You're going to transition the company. But all the rest of you common shareholders, you're not getting anything, right? And us preferred stockholders, we're going to get our preferences, so we're going to do okay. Trados is the case on this to read. The company did everything wrong, right? They had an interested director transaction, right? They had bad evidence, they had, bad comments. It was a sweetheart deal, but they won at the end of the day because it basically the common never had a chance to get anything out of this company anyway. But read it for a roadmap as what to do and what not to do. Other cases, same idea. What's interesting about it is here you have VCs suing VCs, right? It's like that show when animals attack, sharks kind of fighting each other. But all over the same thing. Oh, you did these really egregious terms, and then the company turned around, and now I got screwed and you got rich. we're going to be putting those egregious terms back in the documents. You might want to try to do it in a way that you don't get sued when things do turn around. Well, what are those ways? Well, independent boards. By the way, that doesn't happen as often. They look independent, but the courts don't think so. So make sure it's truly independent. You read the cases, you'll be surprised what independence really means. And even if it is independent, try to comply with this entire fairness standard. That's a fair process and a fair price. And have good process, have good minutes, right? By the way, the board should not be doing anything that's going to hurt a shareholder, casually. By casually, I mean by a written consent or an email. You should have a meeting, have a meeting on WebEx or Zoom or something. Have a meeting, have a discussion, record a discussion, or the fact that you had a discussion in the minutes. Your lawyer should do this. You don't want too much or too little in the minutes. You'd be surprised how people can misinterpret what you write. You won't believe it till you read it in a pleading. But have a good process to make sure you can document you've been careful. Use bankers to value the deal. Do a rights offering, let other people participate in a transaction and shop it. Don't make it non-exclusive to your insiders. All right. I was going to end on a tax slide because it's so much fun, but I'm going to give you guys a break and end on an employment slide. This is big company stuff, but if you do have a mass layoff, make sure you consult your lawyer. You all know that. And finally, you sold all the assets. You did your fire sale. You've got this shell of a zombie company left over. What are we going to do with it? Most people abandon it. I don't recommend doing that for a lot of reasons. One of which is that here in California, at least, your franchise tax board, they will hound you forever if you don't properly wind up and dissolve. And there's a process you can go forward. We have good statutes in California. It's hardly, maybe the only time you'll ever hear me say this, California has good statutes on statutes of repose and winding up companies and freeing yourself from liability so you can turn the next page in life. All right, I'm Roger Royce, partner with Haynes Boone, an international law firm. I am in Silicon Valley office. I'm now going to open things up to questions. So bear with me for a minute. Stop sharing. All righty. All right, use the Q&A box. Why don't I break this up into part 1 and part 2? Okay, maybe I will. Good question. See here, sorry, it's a new technology. I'm getting used to it. All right, I want to talk about a couple other things while we wait for questions. Number one, the piercing the veil issue, because you hear that a lot, and I think it's going to be really important to you that you hope for the best, but you prepare for the worst. And the worst thing that could happen to you is if you end up turning your corporate liability into a personal liability. So one of the ways, like I said, that happens is that creditors, they pierce the veil. They go beyond the limited liability veil of a corporation or a limited liability company. How are you going to prevent that from happening? So every company I put together, not everyone, but hopefully a lot of them, I'll send to everyone, all my clients, a memo that says, hey, you should have annual meetings at least. You should follow formalities. You should do all these things. I think it's really important that you do that. You do follow those formalities. That's number one. Now might not be a bad time, given what's going on, for you to have a board meeting and take minutes. Now might not be a bad time to have a shareholder meeting and take minutes. Now would be a great time for you to document all those shareholder loans and advances back and forth. Because, as I said, following the money is going to be the most important, probably the most important factor here, right? Now would be a great time to stop commingling. If you've been commingling, you know what I mean by commingling. You have one bank account, you didn't get around to opening up a corporate bank account, so corporate money's going into your individual account. Bad idea, bad idea. Stop doing that. Don't do that anymore. Stop it. It's going to get you in trouble. So those are the sort of the biggest piercing the veil issues. Okay. Okay, now I finally figured out how to read these questions. This is not a very friendly screen, I will tell you. Someone couldn't hear me. When's a good time to have a startup, especially in food? Well, you know what? I'll introduce you to some VCs that will tell you that a recession is a great time to start a company. And I think in our last session, we went through some of the great companies that started in a recession. Airbnb started in a downturn. Uber started in a downturn. And then bigger, older companies as well. General Motors, General Electric, they started in downturns, in recessions or depressions. So if you've got the right product, I think now, if you have a product that's in something that's food related, everyone's concerned about health and are concerned about consumer convenience. So if you can play on those issues, now might be a good time to have a startup in those areas. How can we have access to the recordings? They are posted on the Idea to IPO YouTube page. If you send me a link, I'll send it to you. You'll also find it on my YouTube page. Google it, Startup Basics, and it should pop up. What other questions do we have here? Oops, sorry. Must the business have a positive net profit in 2019 to apply for a PPP loan? No, not at all. You just have to be in business as of February 15. So you don't have to be profitable to get the loan, which is one of the things that what you do want to have, though, it's going to be based on your payroll, right? So you want to be able to show payroll because that's how they'll measure the amount of the loan. All right, sorry, this is not very friendly. I got a question here that I can't read for some reason. Oh, non-compete clauses. If they're limited to a year, whoops, sorry. Non-compete clauses. Somebody has a non-compete. That's okay, very fact-specific case. I covered non-competes in one of the prior presentations. I've got a really good discussion about that. It very much depends on state law. If you want to go to those presentations, so it was the part one of the venture capital terms presentation. And I also cover it in my startup basics as to when non-competes are enforceable and when they're not. I know there's more questions here. Somebody had a question about IP. Here it is. How can we secure intellectual property transactions working with international partners? Well, not really our topic, but I'm happy to talk about it. Again, probably covered in a prior presentation. So here's the thing about intellectual property rights. They are state specific, they're geographic in scope, they're enforced individually by countries. That's why you need foreign patent rights. So I don't know if this is what you mean, but I'm going to give you a big broad answer and hope it hits your question. So if your IP, if your intellectual property is patent, that's a very valuable asset, by the way. That patent is, like I say, it's very specific to a territory. So you'll file in the United States for patent protection in the United States. And then in most countries subject to treaty, you have a year to file in those countries and get protection in those other countries. So if it's registrations, that's how you protect it. If it's trade secret, which is most of the IP that I see, in my practice, I'm not a patent lawyer, then it's a matter of contract and local law. And here's the tricky part is it's tougher, I think, than patents where you've got a statutory scheme. It's really going to depend on the local law of both jurisdictions. So for example, let's say this happens a lot for my clients who will outsource and hire contractors to do technical work in another country, but they want to own what it is that they develop. They have to comply with the law of the US because they're a US company doing business here, but you don't want somebody stealing that property away from you in the foreign country. So they want to comply with the law of the foreign country as well. You want to comply with both sets of laws. That's how you secure those IP rights. What else do we got here? Why do you think the current downturn will not be as bad as 2008? Well, I think I don't think it will be as bad. I'll tell you why. Because I think the metrics are way different. This is without getting political. I mean, this is somewhat of an artificial downturn. This is a downturn that was forced upon us. It was regulated, right? And for whatever reasons, you can blame COVID, but it was basically regulated. And all of these restrictions, they're not organic. They're going to go away as the sheltering comes off and people are going to go back to work. Now, don't just take my word for it. Like I say, the venture community in 2008, they looked around and they saw systemic problems in the economy that they could see was going to take a long time to fix. The venture community now is looking around saying, might get some better valuations. You know, the market was a little frothy. You know, look at my last presentation. Venture's been strong. A lot of money in this ecosystem. You know, I think we'll just wait a little bit and then invest. That's way different than 12 years ago when people are saying, we're done. You can have your money back. You know, East Coast, you know, limited partners. We're just not going to spend it because there's nothing out there that's worth spending it on. This is way different in my neighborhood. Plus, there's so much more opportunity. You know, one of the things that we've seen out of this downturn is models that have really evolved and become way better. I will give you one good example. Idea to IPO. We used to do this presentation live, right? We did this live every week, several times a week. We're not doing it live anymore, and we're reaching way more people. There are more people sitting in this seminar now than will be at a live presentation, especially with Silicon Valley traffic, right? Plus, a lot of people are going to view the video. So this is a new model that has come up. So I think there's opportunities that have come up. I think the economy is going to recover. And honestly, just take a look at the metrics. You know, unemployment isn't nearly as bad as people thought it would be. The economy is stronger than people thought it would be. The stock market has been doing better than people thought it would be. I'm afraid to look myself, but you know, I listen to the news. They tell me it's not so bad. So, and real estate has not yet crashed. I don't know if it will or not, but that was heavily predicted as well. Now, you know, I'm a lawyer, not an economist, and other people disagree with me. But from your standpoint, I'll say what I'm trying to tell you is that you should prepare for a recovery, and you should prepare for yet another dip before that recovery, right? And I want you to be around for the recovery. So I don't want you to make a legal mistake during the dip that tanks your business, right? So, and I don't want you to make a legal mistake during the dip, you know, that gets you sued during the recovery. That's what most of these presentations have been about. So I think, yes, we prepare for the worst and we hope for the best. And I hope this helps. Trying to scroll down. What are fundraising ideas for a SaaS that is not launched? No customers or revenues, no VC money, not be an IPO. Will the SBA lend to such a company? No, I mean, you've got to have a business, you know, to get the PPP loan. Well, a couple of things. So you had to have been in business to get an SBA loan, first of all. Secondly, these are loans, right? You are going to have to pay this money back. And for a company like that, that sounds like a very high risk business. Debt is not appropriate, not even government debt, because it doesn't sound like you're going to qualify for some of the stimulus money. I guess you are too small. I guess you can't be small enough to fail. So instead, you might find yourself in another category of loans that, you know, where there are personal guarantees, there is security, there's stuff like that. So I'd be very careful about that. I think this is a great time to launch a company, but it's a great time to launch a company with maybe non-dilutive financing like grants or pre-sales or revenue, or equity capital or safe notes or convertible notes or things like that. But now that I look, but you do have a business. Okay, I misunderstood your question. So you've got a business, you just don't have a lot of revenue. keep in mind, these loans are going to be based on not only revenue, but on payroll. So if it's a PPP loan, it's going to be based on your payroll. So if you got payroll, then yeah, you'll qualify for the loan. I thought you said you had not yet started the business. My bad. Any negatives for applying for a PPP loan? Yeah, there is one. You don't get that tax credit I was telling you about. If you take $1 of PPP money, then you don't get the tax credit. Remember the tax credit? If you do all the math, it's complicated. It works out to about $5,000 per employee, up to $5,000 per employee. All right, that's a credit. It's a refundable credit. It's against payroll taxes. You don't even have to have income tax to get this money back. It's an example of the IRS using its facilities to facilitate social programs. They do that once in a while. So that is the one big negative. The other thing to keep in mind is that well, it doesn't sound like much, but it is a 1% interest rate. So there is a cost to it. You do have to pay the money back. Trying to read this. What are your inputs on getting financial support to start one? Not sure I understand the question. So maybe you could add to that. But people want to talk about the loans. I guess the thing to keep in mind is when this loan program first came out, the money, ran out in a hurry. In fact, people applied so quickly that you would just have to conclude there's fraud in the system. You would just have to. I mean, how could people have applied so quickly? They must have been ready and waiting, but maybe not. Whatever the case, the money ran out quickly, but then it was re-up. And if you listen to what Treasury is saying these days, you get the feeling that they feel like they have a printing press and they're going to print as much money as they think they need to. I wouldn't count on that, but I tell you what, the two things that are for sure is we'll probably see more changes in this program. We're up to 24 weeks of forgivable loans now. That's huge. There's more money available. You can apply today. Just this morning, I read that there's a talk in Congress about just having an automatic, no questions asked, $150,000 forgiveness. So these terms are getting, just looser and looser and looser and looser. It's like, God, it's like FDR and the Great Depression again. So if I'm not saying you should take that money, I'm just saying that it's awfully free. What do you think about starting an infrastructure company, renewable energy generation? Is a downturn the right time? What are your inputs on getting financial support? Well, again, I'm just a lawyer, but I think this downturn is going to be short and shallow. I could be wrong, and a lot of people who are smarter than me disagree with me. But that being the case, then yeah, this is a fine time. The trouble is your valuations are going to be a little weak. So when you take that money, take it on a convertible instrument that will convert at a later valuation, like a convertible note or a safe. And by the way, we talked about safes last time, but remember, safes have a valuation cap. So the way a safe and a convertible note works, if somebody says, look, I'm going to give you money today, but I don't want to value your company today. So I don't want stock. Instead, what I want is I want a right to buy. I'm looking at the wrong camera this whole time. I want a right to buy stock in the future at a discount to the valuation then. All right. So that's fine. That's a safe. But then they think, well, gee, what if that valuation is super high? On my 100,000 now it buys like 0.001% of this company instead of the 0.1% I should have. So we'll put a valuation cap and we'll say, no matter what happens with the valuation down the road, I get at least this much stock. All right, so that's a valuation cap. What I've been seeing now is valuation caps coming down, just anecdotally. And I was telling people you should have a $10 to $12 million valuation cap on even your startup, your unproven, untested idea. And this has been coming for a long time. It wasn't just the last few months, but I've seen those valuation caps coming down and down and down and down. And I've heard some VCs say they expect them to go back to 2008 levels, meaning you will be financing your company at like $3 and $4 and $5 million valuations. God, I hope not. So that's the downside of financing a company during a downturn. The way you protect yourself is you do a convertible instrument. The negotiation you're going to have is going to be on a valuation cap. All right. I think we've got through other questions. If any of you have additional questions, I'd invite you to email me. My email address isn't on the screen, but I'm not hiding. I'm easy to find. Just Google Roger Royce, Haynes and Boone. You can find it on the ID@IPO webpage. You can also find me on LinkedIn, follow me on Twitter, friend me on Facebook, pin me on Pinterest, take a picture of me on Instagram. You'll find me in all of those venues. Track me down. I'm happy to share the recording of this with you. I'm happy to share the last materials. I had a copy of my book here. I'd wave it in front of me. Happy to share a digital copy of my book, Dead on Arrival, How to Avoid the Legal Mistakes That Could Kill Your Startup. Want to thank you for tuning in. One last question. This is the last one. You know, I just gave you an hour on legal issues. I haven't gotten any legal questions here yet. Somebody wants to know if it's going to end before there's a vaccine. Talk about being beyond my pay grade. Although I just did a fireside chat with Nobel laureate Thomas Sudoff, you should Google it. He talks a lot about vaccines and how effective they are or ineffective. So he could answer that question. He's a Nobel Prize winner and a Stanford professor and doctor. I can't. By the way, I'll leave you with this because I got a lot of questions where people are asking me to look in my crystal ball. But you don't have a crystal ball? I thought we all did. And my crystal ball, it's in the shop. It's not doing that well. So I can't answer that. But you know what? There's not a lawyer in the world who can tell you what is going to happen. Not one. All we can tell you is what might happen, what's likely to happen, what could happen, and what you can do in case that does happen. What you can do to protect yourself if that bad thing happens. What you can do to profit if that good thing happens. That's all we can do. So as you kind of go through these slides and maybe study them later or watch this video again, just keep in mind, what we're trying to do is set you up for contingencies. And we've got a little bit better visibility into what kind of contingencies we expect may happen. We've got experience and background for what successful companies have done to get through troubled times like this. So take advantage, of that wealth of experience that's out there and be prepared. Don't make any mistakes, and let's all live to fight another day. Thank you. I'm Roger Royce, Haynes and Boone, and I'm going to go ahead and conclude the webinar.